Very good morning to one and all present. Today we have gathered for the 74th Study Circle meeting. The topic for the meeting is Nurturing Life and Liberty of People and Constitution of India as a Forerunner. And we have two eminent judges from the High Court of Madras and the Supreme Court of India to address us on this topic. I invite Senior Advocate Mr. Om Prakash from the Madras High Court to give the welcome address for the session.
A very warm morning to one and all. It is indeed a great privilege and honor to welcome our honorable judges and participants to the webinar of the study circle. Despite the pandemic, we all found avenues to continue our learning by adopting to new technological advancements. The study circle is an initiative that has been able to reach a large extent of people across the country since the pandemic. After 73 sessions on various topics touching law and literature, we have joined today for a session by honorable judges on nurturing life and liberty of people, Constitution of India as a Forerunner. It is needless to say that the topic carries significance at every point in time, even more so in today's context. It is our honor that Honorable Justice Indira Banerjee, Judge, Supreme Court of India, and Honorable Justice T. Raja, Judge, Madras High Court, have accepted our invitation to speak on this interesting and essential topic. Her Ladyship, Justice Indira Banerjee, started her career in law as an advocate in the Calcutta High Court in 1985. After 17 years of successful practice in various branches of law, her Ladyship was elevated to the bench of Calcutta High Court. Justice Indira Banerjee has presided over as Judge of Calcutta High Court of Delhi, and later as Chief Justice of Madras High Court, before being elevated as Judge of Supreme Court of India as the 8th women judge in its history. Her Ladyship is part of many historical judgments in Supreme Court, like right to property being dealt with in the case of B.K. Ravichandra versus Union of India, reported in 2020 SEC Online, deprivation of liberty in cases of remand orders in the case of Jagdish Arora versus State of UP, reported in 2019 SEC 619, mental illness as a mitigating factor in death row convict in the case of X versus State of Maharashtra, reported in 2019 7 SEC 1. These are only a few to quote. As you are aware, cases of arrest, bail, anticipatory bail, when being dealt with, the Lordship's decisions have been Forerunner. His Lordship Rajendra has a practicing career ranging from tribunals to Supreme Court of India. Within 2 years of his enrollment as an advocate, Justice Raja had established a successful practice in New Delhi, practicing from CAT, various statutory appellate tribunals, High Court of Delhi and Supreme Court of India, and did not restrict to any particular jurisdiction. His Lordship later in 2008 was appointed as Additional Advocate General, Government of Tamil Nadu at Madurai Bench of Madras High Court, and was elevated to the bench in 2009. Ever since then, there had been no looking back to the dispensation of justice on various subjects, and many judgments of His Lordship speak for itself. Justice Raja has to his credit multiple lectures on Constitution of India, touching upon basic structure, Land Acquisition and Resettlement Act, etc. His Lordship as an advocate was largely instrumental in the challenge to the amendments to CPC in the Salem Bar Association case, leading to the laying down of law as a guiding principle for years to come. Our speakers are eminent personalities in their respective bars and are known for their immense knowledge and sincerity to the subject being dealt with by them. Even after elevation, they have remained as simple and humble personalities. Honorable Justice Raja was kind enough to accept our invitation to address on the topic and had been guiding us throughout till this minute. I should acknowledge the graciousness and benevolence of Honorable Justice Indira Banerjee, whom we had not even approached in person, and her Ladyship was kind enough to consent on being reached over phone. Thanks to Mr. Naveen Kumar, the Personal Secretary of her Ladyship, for the coordination. I thank my friends in Bar who had been very helpful in every endeavor and the various knowledge-sharing platforms, namely Legal Elites Group, Madras Tax Bar, Beyond Law CLC, SRS Lex Webinar, and many more. I also acknowledge the presence of Honorable Judges of High Court and Supreme Court for this session and extend a very warm welcome. But for your inspiration and motivations, the knowledge-sharing sessions would not be possible. Last but not the least, the participants for the session, a very warm welcome to you all. Now I invite Honorable Justice Indira Banerjee to address the session.
A very good morning to all of you. It is always a pleasure to be back with my brothers and sisters from the bench and from the bar of Madras High Court. My experience in Madras High Court, though short, only of 16 months, was indeed very sweet. I nurture very happy memories of my stint of 16 months as Chief Justice of Madras High Court. And I'm thankful to my brother and sister judges and the lawyers of Madras High Court and other courts in the state of Tamil Nadu for all the cooperation which was rendered to me while I was Chief Justice. When I was approached by Justice Raja 3 days back, I was, if I may use the expression, in a bit of a soup because of a fairly tight schedule. But yes, I appreciate the difficulties of the Chief Justice of Madras High Court. Having been the Chief Justice of Madras High Court myself, I know of the immense responsibilities and commitments. He was unable to join in. So if it was not the current Chief Justice, then it's a past Chief Justice. And I readily agreed. I've never stood by formalities. So the question of coming all the way to Delhi to invite me personally just cannot and does not arise. But I would have been happier if I had a little slightly longer notice, because I could have been a little more prepared, because I know I'll be addressing a very knowledgeable, well-informed audience. And you know, mother wit, it's good at times, but thank you for giving me the opportunity to share my thoughts on you on a subject which is extremely important. I congratulate the lawyers of Madras High Court who have formed this study circle for dissemination of information. And even during, you have been conducting webinars on various important topics. The topic today is nurturing life and liberty, Constitution of India as a forerunner. What an apt topic for lawyers of the Madras High Court. After all, the earliest very important cases on life, on the right to life and liberty, and the right to liberty of thought expression in the form of freedom of speech, came from Madras. Your A.K. Gopalan versus State of Madras, relating to the right to personal liberty, and your Ramesh Thapar versus State of Madras, relating to freedom of speech and expression, and many others. But these are the most, these are the judgments which any student of law, of constitutional law, is made to read at the basic level. On 26 November 1949, President Rajendra Prasad congratulated the members of the Constituent Assembly for framing the largest constitution in the world, which at that time comprised of the preamble, 395 articles, and 8 schedules. The 9th schedule, as we all know, came with the first Constitution Amendment Act. The drafting committee of the Constituent Assembly, chaired by B.R. Ambedkar, comprised of stalwarts like Alladi Krishnaswamy Iyer, Gopal Swamy, K.M. Munshi, and others. There was a lot of discussion and deliberation. B.N. Rao was advisor, and it is said that he had actually prepared the initial draft of the Constitution. He also contributed immensely to the drafting of the Constitution. He was not exactly a member of the Constituent Assembly. He was an advisor. Now, the vision of the Constitution makers, what exactly the Constitution makers wanted, the philosophy behind the Constitution is stated in its preamble. We have a people-centric Constitution. The committee drafted the Constitution on behalf of the people, as representatives of the people. And the people adopted and gave themselves a constitution. This is very important. When we try to understand the Constitution and implement the constitutional values and constitutional principles. The people of India constituted India a secular democratic republic. Your secular and socialism were added later by the 42nd Amendment Act. And the Constitution promises to secure for all its people justice, social, economic, and political. Liberty of thought, expression, belief, faith, and worship. Equality of status and of opportunity. And to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Again, a little bit of amendment by the 42nd Act. What runs through these various aspects which have been guaranteed by the Constitution? Justice, the liberty, equality, fraternity. What is at the root of it all? At the root of it all is the right to life. Because the others refer to the quality of life. And of course, if there is no life, then where is justice? If there is no liberty, personal liberty, where is the liberty of thought, expression, belief, faith, and worship? Now, as stated by the Supreme Court in the Berubari case, The preamble is the key to the mind of the constitution makers. Of course, in the Berubari case, Justice Gajendra Gatkar, speaking for the people, did not consider the preamble to exactly be a part of the constitution itself. But the interpretative value of the preamble was recognized even in the case of Berubari. In Sajjan Singh versus State of Rajasthan, Justice Madholkar said that the preamble had a stamp of deep deliberation, was marked by precision, and the framers of the constitution attached special significance to it. I quote. We went a long way in the case of Keshavananda Bharati, where the majority held that the preamble was very much part of the constitution. The constitution is the soul of the nation, and the judiciary is the guardian of that constitution. It is for the judiciary to interpret the constitution. How effective the constitution is going to be, how the constitution can be worked out, depends on how the constitution is interpreted by the judiciary. The provisions have to be and have been given a purposive interpretation to advance the cause of justice. Now, the law evolves through study, through discussions, through exchange of ideas, and symposia, seminars of this kind, webinars conducted by the study circle will certainly go a long way in the evolution of the law. I haven't the slightest doubt about that. There is also another very important thing which I have always acknowledged, and I can't forget the fact that I was a lawyer myself for about 16 and a half years before I was elevated as a judge. When we talk about judging, it is the judges who deliver the judgment. They are the author of the judgment. But much of what is written depends on the kind of assistance which is provided by the lawyers. And I, for one, have no hesitation in admitting that the best judgments that I have delivered in my judicial career, which is almost of 20 years now, is attributable to the quality of the arguments advanced by the various lawyers appearing on behalf of the respective parties. I also have to acknowledge the contribution of a great lawyer to my career in law. Though principled as he is, he never appeared in my court while I was in Calcutta. And that is Mr. S. Pal, the better half of my predecessor in office, Justice Ruma Pal. the author of books on contempt of court, constitution, public service, and the like, in whose chamber I devilled, and in whose chamber I really started learning the alphabets of constitutional law. We have ourselves seen the changes in the mode and manner of interpretation of an article which is most fundamental to all the provisions of the Constitution of India. The right to life and right to personal liberty. What does this provision read? It says, no person shall be deprived of his life or personal liberty except according to procedure established by law. This provision was interpreted by the Supreme Court in the case of A.K. Gopalan. The court went by the plain meaning of the words used in the Constitution. It is very interesting. I'm deviating a little. You know, when the Constitution was drafted, there were debates almost over every provision of the Constitution. There were debates with regard to this article as well. And there was a suggestion that instead of the expression, no person shall be deprived of his life or liberty except according to procedure established by law, it was suggested that it should be except according to due process of law. And the Constitution as drafted, though it had provided that no person would be deprived of his life or liberty except according to procedure established by law, had a second limb. And that second limb was, shall not be denied equality. That was separated. It became Article 14, which specifically provided for the right to equality, and the right to life and personal liberty became Article 21. Now, after A.K. Gopalan, where the court restricted the right not to be deprived of liberty to the right not to be literally to the right not to be deprived except according to procedure by law. That is a law enacted by a competent legislative body. But the court did not go any further. And the court was of the view that the different fundamental rights were compartmentalized. A complete change in the view came with the judgment in the case of Maneka Gandhi in 1978, when the court was of the view that there should not only be a law, but a law which was not arbitrary. Principles of natural justice were read into procedure established by law. This is how our Constitution, by an interpretative process has possibly become the forerunner. And one just has to look at the expansion after that. The MC Mehta cases, where the Supreme Court took the view that, the right not to be exposed to polluted air, that was also part of the right to Article 21. The right to a clean environment has been construed as part of the right to live under Article 21. In Sunil Batra versus Delhi administration, the Supreme Court was of the view that the right to health is part of the right to live under Article 21. In Husainara Khatun, the right to a fair, speedy trial was considered to be part of Article 21. In Bodhisatta Chakravarti, it was the Supreme Court found that rape, which which ripped a woman apart, which ripped the dignity of a woman apart, was violative of Article 21 of the Constitution of India. And in Chandrima Das, the Supreme Court directed the state to pay compensation to a victim of rape who had been raped within railway premises, within a railway rest house. And this was in a public interest litigation. Chandrima Das was a lawyer, she was not the victim herself. Today, we have a whole lot of public interest litigations where people have come forward to agitate the rights of those who are not in a position to come to court themselves, to agitate their rights. For example, the ill treatment of mentally disabled persons, the chaining of mentally disabled persons, police atrocities in custody, fake encounter and the like are very obviously violative of Article 21 of the Constitution of India. But we have gone far ahead. Today, possibly all the basic ingredients of a life of dignity, the right to food, I would say, the right to shelter, the famous Olga Tellis case of 1986, and what was stated by P.N. Bhagwati. I'm extremely sorry, Raja, I've eaten into your time. I'll stop here and now. So I'm sure you'll have an interesting discussion. And Madras High Court has been a forerunner with the judges and the lawyers of Madras High Court. The constitutional values will be given better expression. When we talk about all these rights, we cannot lose track of independence, impartiality, integrity of the judiciary. These are very basic qualities of the judicial system. The judiciary has to be independent. The judiciary has to be impartial. Equal justice has to be done. When there is violation of life and liberty, the judiciary has to intervene, no matter how high and mighty the person who is violating the right. And at the same time, the judiciary is not necessarily the leader of the opposition either. Depending on the facts of the case and its honest interpretation of the law, a decision has to be taken. A decision which renders complete justice and ensures life and liberty are intact. There are issues which will arise. Let us say, take the relatively important case of Puttusamy, where even the right to privacy has been considered to be covered by Article 1 of the Constitution of India. Today, a situation arises, or let us say it had arisen maybe a year earlier, where in public interest, the authorities would put up posters in a locality where a patient was detected of COVID. Now, this was possibly done with a view to spread the infection. But how do you gel this with the right of privacy, which is now part of Article 21, which is the law which permits such a measure? These are issues which will come up in the future. Now, there was an earlier case you are all probably aware of, where a patient of AIDS, the doctor had divulged that the groom had been suffering from AIDS. And the HIV positive patient complained of violation of right to privacy and also breach of medical ethics on the part of the doctor in making the revelation. But the courts in that case did not uphold the contention of HIV positive patient because it felt that the doctor also had a duty to the prospective wife, who otherwise definitely would have got infected if the disease had not been divulged. There will be problems and problems and problems. There have been so many judgments in would take days to cover them all. But I can only wish Study Circle every success in its endeavors. And I do hope the judges of Madras High Court are able to uphold the very valuable basic right in the Constitution of India. 395 articles, but some of them absolutely basic, absolutely fundamental. And after Keshava Nanda Bharati and others, part of the unalterable feature, structure of the Constitution of India. I thank you very much, and I'm sorry I've taken up more time than was allotted to me.
Thank you, Your Ladyship. I now invite Honorable Justice Mr. T. Raja to give the keynote address.
My Lord, Honorable Justice Indira Banerjee, Judge Supreme Court of India, Mr. Om Prakash and his teams organizing study lectures through webinar series, choosing very interesting and novel topic, nurturing life and liberty of people by the Constitution of India as a forerunner. I also thank the organizers for having chosen very useful topic with a laudable object to enlighten the members of the legal fraternity. Good morning to all of you. I congratulate the organizers for taking very active interest. I wish they should continue to carry on the same for the benefit of the legal fraternity, common men, and also for the interest of the institution. Before going to the topic, let us visit the Constitution first, because we must know what is our Constitution, the importance of the Constitution, what the founding fathers of our Constitution has visualized for us and also for the future generation. The very object of organizing this webinar session is to enlighten the members of the bar. So therefore, just before going into the topic, let us see what is our Constitution for a few minutes. Constitution, we generally know, many people used to say, is a living document, supreme law of the land, the fundamental law of the land. No doubt it is supreme law of the land. But we must also know what is the fundamental law of the land. How do we say that the Constitution is called, considered, and appreciated by one and all as the fundamental law of the land? These are all the reasons which I would like to enlighten the respected audience today. Constitution guarantees the fundamental rights to all its citizens. When the Constitution guarantees the fundamental rights to its citizens, it also directs the state not to take away, not to infringe upon the rights guaranteed by the Constitution of India. So first of all, it guarantees the fundamental rights to its citizens. While guaranteeing the fundamental rights to its citizens, it also commands the states, including the central government, the state government, the local authorities, all other instrumentality of states, not to infringe upon the rights conferred by Part 3 of the Constitution of India. Look at the command given by the Constitution of India, commanding the states, state legislatures, the union government, all other instrumentality of states, not to infringe upon the rights guaranteed. The more important thing is, it also further says that if the state infringes, damages, or takes away any guaranteed rights arbitrarily, you can just rush to the Supreme Court. You can just go to the High Courts, which is nearer to you, under Article 32 of the Constitution, and also under Article 226 of the Constitution. You can complain to the Supreme Court that your rights guaranteed by the Constitution has been infringed upon, damaged, or taken away. The Constitution further says that the Supreme Court and the High Courts, being the custodian of the fundamental rights of the citizens, the custodian of the Constitution, the life and liberty of the people, it will protect the citizens from losing the Constitution, from losing the fundamental rights, and then it will protect, finally, it will enforce your life and liberty. Therefore, we call the Constitution is a fundamental law of the land. To make it more clear, if you just see Article 1, to make it clear that the Constitution is a fundamental law of the land, let me tell you from Article 1 how the Constitution of India is called the fundamental law of the land. Article 1 says, India, that is Bharat, shall be a union of states. So Article 1 says, your country's name, India, that is Bharat. Secondly, it says that India is a union of states. So therefore, we call the Constitution is a fundamental law of the land. It gives you the fundamental facts, the fundamental aspects of your existence. Coming to Article 3, it gives enormous power to the Parliament to make one state into two states and two states into one state. It gives enormous power. And if you go to Article 5 to 11, it deals with the citizenship rights, the citizen, how to acquire the citizenship. Let us not go to these areas. Let us go to Article 12 to 35, the fundamental rights, Part 3 of the Constitution of India. Part 3 runs from Article 12 to Article 35. I'm just telling you, a lawyer, a student of law should know what is fundamental law, how the Constitution is considered and called as fundamental law of the land. The Constitution tells in Article 14, the state shall not deny to any person equality before law and equal protection of law within the territory of India. Look at the wordings. I must again say it is a command. The Constitution tells the state governments, both the state government and also the central government, it tells that either the state government or the central government or any government or any instrument or state not to deny the equality before law to any person within the territory of India. And if you just come down to Article 15, it says the state shall not discriminate any citizen on grounds only of race, religion, caste, community, sex, or place of birth, or any other. So, this is the basic principles upon which the Constitution has been framed. Therefore, we say the Constitution of India is a fundamental law of the land. Again, if you just move on from Article 15, I will tell you our topic is also covered by Article 15. Article 15 says that, as I mentioned, the state shall not discriminate against any citizen on grounds only of race, sex, place of birth, or any one of them. If we just go down to Article 15.2, our topic is almost covered. It says that no citizen shall be subject to any disability or liability or restrictions or even condition with regard to access to shops, public restaurants, hotels, places of public entertainments. And it also says that no citizens shall, on grounds only of religion, race, caste, sex, place of birth. If we just go to Article 15, Article 15.2, I would say, it almost covers our topic. Nurturing the life and liberty of people by the Constitution as a forerunner. How do we say that? Article 15.2 says, no citizen shall, on grounds only of religion, caste, community, sex, place of birth, be subject to any disability, restrictions, or even conditions with regard to access to shops, public restaurants, hotels, and places of public entertainment, or even in the case of use of wells, tanks, bathing gates, roads, places of public resorts maintained wholly or partly out of the state funds. Let me take it as an example. I belong to a weaker section. Let us push in that. I'm a person doing scavenging work. I'm a person doing the cleaning up of the roadside drainage. Can anyone in India tell me or subject me to any disability that I, being a person doing only the cleaning up of the drainage on the roadside or removing the human waste on the roadside, you will be subject to these conditions that you should not enter into any hotel. Your entry is prohibited into any hotel, cinema hall, or any shopping mall, etc. Article 15.2 will come to my rescue. My life and my personal liberty has been protected, preserved. If anyone stops me, prohibits me, restricts me with all these disability conditions, restrictions, I can just go to the High Court. I can just complain that I'm not allowed to go into the restaurant. I'm not permitted to go to the cinema hall, even any places of public entertainment. The court being the custodian of the Constitution, the custodian of the fundamental rights of the citizens will come and then immediately redress the grievance. Therefore, Article 15(2) says that the life and liberty of the citizens shall be preserved, shall be safeguarded at any cost. Let us go to Article 16, equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters of employment or appointments, either in the state service or the central service or any other office. If we just go to Article 17, the practice of untouchability has been abolished. It says, Article 17, the untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Friends, look at the wisdom, look at the fortsightedness of the founding fathers of our Constitution. They said a weaker section belonging to the scheduled castes or scheduled tribes, if they are all treated very badly like animals, this is nothing but encouraging this slavery. Article 17, in an effort to nurture the life and liberty of the citizens, says that if anyone in this country within the territory of India is practicing the untouchability, he will be punished because it is a punishable offence. The reason being that the life and liberty of the citizens should be safeguarded. This is how Article 17 has been nurturing the life and liberty of every citizen in our country. Just let us go to Article 18. Article 18 says, you cannot even use any title either behind your name or before your name. Just see how the life and liberty of every citizen has been safeguarded. It says that, Mr. Raja, you are not supposed to use behind your name or before your name any title, like the Raja Pillai, the Raja Sethi, the Raja Ayyar, the Raja Mudaliya, the Raja Teva. If you use it, Article 18 will bounce upon you. The meaning, the reason, the purpose for which Article 18 has been brought in the Constitution of India is to say that if you are claiming that you are Raja Mudaliya, it goes without saying that you are indicating that you belong to a higher caste and then the other belongs to the lower caste. As a result, the person belonging to the lower caste, the lower community, his life and liberty will be impaired. Therefore, please do not use your title except the academic distinction and military distinctions conferred by the government. Again, if you just move on to Article 19. Article 19 guarantees, originally guaranteed 7 fundamental rights. It says that all citizens shall have the right to freedom of speech and expression, Article 19(1)(b). 19(1)(b), all citizens shall have the right to assemble peacefully and without arms. All citizens shall have the right to form an association or union, including with property societies. All citizens shall have the right to move freely throughout the territory of India. All citizens shall have the right to reside and settle down in any parts of India. All citizens shall have the right to carry on any business, trade, or commerce, or any occupation. One of the articles, namely right to hold, acquire, and dispose of property, has been completely taken away by the Janata government in 1979. Now we are left with 6 fundamental rights. Without these fundamental rights guaranteed to the people, your existence as a human being would become meaningless. Your life and liberty cannot be cherished. Therefore, Article 19 has been embedded in the Constitution and it has been guaranteed to anyone. If we just move on to Article 21, it deals with the life and liberty of the person. You cannot take away them without following the procedure contemplated. Let us go to the macro level of life and liberty. We'll come back to Article 21 later on. Similarly, if you just come to Article 23, Article 23 clearly says that it prohibits the traffic in human beings and forced labor. If a person is working as a slave, naturally he will not be able to enjoy his life and liberty. Therefore, Article 23 prohibits the traffic in human beings and forced labor. And then Article 24, prohibition of employment of children in factories. If a child is below the age of 14 years and he is not permitted to work in any factories as per the Constitution. So if we just look at the Constitution from 1, it talks about the life and liberty of the persons. It guarantees the fundamental rights. It safeguards the life and liberty of the persons. Friends, I was just mentioning about one very important aspect, that Constitution of India is a fundamental law of the land. Let me also indicate how this can be construed as it could be understood as the fundamental law of the land. We just go to Article 52. From Article 12 to 35, Chapter 3 deals with the fundamental rights that has been guaranteed by the Constitution of India. From Article 36 to Article 51, Part 4 deals with the direct to state policy. We'll come back. If we just go to Article 52, to make my point clear that Constitution of India is a fundamental law of the land. As a student of law, it is our duty to explain to you that the Constitution is the basic document, is a living document, is a fundamental law of the land. You must know that if Article 52 is read out, it says, there shall be a President of India. President of India, by virtue of Article 52, comes into existence. If you see Article 53, subclass 1, now the President of India has come by virtue of Article 52, because the Constitution has created the President of India. How the President of India can be vested with power? Article 53, subclass 1 says, the executive power of the Union shall be vested in the President who will exercise either directly or indirectly through his subordinate officers. Article 53 has vested all the executive power, and then today the president has become the chief executive of the nation. 53 subclass 2, he gives the supreme command of the armed forces of the Union to the President of India. The supreme command of the defense forces of the Union shall be vested in the President. Now, President comes by virtue of Article 52, by virtue of Article 53 subclass 1, President of India is vested with the executive power. 53 subclass 2 says that he is also vested with the supreme command of the armed forces of the Union. Now the president has got its full form. Just go to Article 56. Article 56 says that the term of office of the president shall be for 5 years. Friends, I'm just giving a small illustration. Let us take for example, take me for an example, that for a minute that I'm the President of India. I've been appointed. Executive power is vested with me. Supreme command of the armed forces of the Union is also with me. So I have become all powerful. Now the question is, Article 56 says that the term of office of the president shall be for 5 years from the date he is entering upon his office. Friends, we all know that. Today, the entire world is facing a very peculiar, unprecedented situation. COVID-19 pandemic situation has infiltrated every nook and corner of the world. As a result, we are not able to move from one place to another place. More particularly, even the flight services are also, international flight services also have been completely suspended. Now, being the President of India, I'm saying that for the last 1 year, my term has been completely reduced to 4 years. I have given a promise to US. I have given a promise, I already planned to go to Switzerland to enter the treaty for India. I have also given a date to Belgium. There I have to go and enter into agreement. 5-6 agreements I have to do it. As a result, the trade and commerce can progress. With the result, the life and liberty of the people will be nurtured. Now, in view of this 1 year lockdown, I'm not able to go. Therefore, I'm just extending the period from 5 years to 6 years because 1 year I have lost it. I'm just confined within my Rashtriya government. Can President of India extend the period from 5 years to 6 years? And he can also cite an example. The Honorable Supreme Court of India also in one of the suo motu petition has excluded the 1 year period commencing from 15/3/2020 till 15/3/2021 for the purpose of calculating the limitation. That shows that the 1 year period can be just extended. Take the case of even Tamil Nadu government. It is extending from 58 to 59 and 59 to 60. They are extending the period. So similarly, I have been unnecessarily become the victim of this Forerunner. 1 year I lost. Therefore, I'm extending the period from 5 years to 6 years, only for that purpose. The question is today, whether the Constitution would allow this type of initiation, this type of expansion of this 5 year period into 6 year period because of this peculiar situation we are faced. Article 54 will jump along with Article 326 of the Constitution. Both Article 326 and Article 54 will join together and then retreat, will give a negative answer to it. Article 54 says how a president shall be elected. A president shall be elected by the members of the electoral college consisting of both elected members of the houses, both the Rajya Sabha and the Lok Sabha. And also the electoral college means the Rajya Sabha, Lok Sabha, and also the legislature of states. Now, the member of parliament belonging to both houses of the parliament, they should vote for electing the president. The members of the legislative assembly of each state has to elect and cast their vote for the purpose of electing the president. Therefore, Article 54 comes in. Unless these electoral college elect a person as a president, the president cannot come in. And then if we just go to Article 326, he says that he gives the right to vote to Indian citizens. A person who is above the age of 18 years is entitled to cast vote, and the adult suffrage is given to Indian citizen if he is above the age of 18 years. So he would say, I have to elect my own member of parliament. I have to elect my own member of legislative assembly, and they will elect the president. They will elect the other people. Therefore, the expansion, the calling for the expansion of this 5-year term into 6-year term cannot be possible. I'm just indicating for a moment to make one point clear that how the Constitution of India has put the checks and balance everywhere for the purpose of nurturing, preserving, protecting the life and liberty of the persons. This is for only simple example. If I am a good person, if the President of India is a very fair, impartial, well and good. If for any reason he is just going and then using the powers vested in him, what will happen to the life and liberty? Anticipating all these things, the Constitution of India has given the checks and balances everywhere it is possible. Therefore, we say the Constitution of India is the fundamental law of the land. Coming back to the topic, nurturing the life and the work of people. Friends, we have seen Article 14. The state shall not deny to any person equality before law or equal protection of law. Article 15 says that no citizen shall be discriminated. The state shall not discriminate any citizen on grounds only of religion, race, caste, community. And it goes on in this. But when it comes to just our part of India, to make one point very precise, I will take you to 1937. In 1937 and 1935, 36, Burma was part of India. Just 10 years before we obtained independence. That was in the year 1937. One of our leaders, Yemen Roy, he said that the India should have the Constituent Assembly in the year 1934. Anticipating that if India is given the Constituent Assembly, namely the Constitution will be coming, then they would say unity and integrity is a part of this nation. What happened in the year 1937? When Burma was part of India, the British government took away Burma and gave them independence. Now, Burma today, which is called Myanmar, is gone independently outside the scope of the Constitution of India. I'm just indicating it's not true. We know that what is happening in Burma, what is happening in Myanmar, only to make you appreciate how the life and liberty of our own people, once upon a time they were part of India, are facing the regimentation today. The leaders, political leaders, even writers, cartoonists, social activists, they are completely arrested and they are put behind the bars. No freedom. Social media has been completely banned. Burma was part of India. 1937, it went out of Indian Union. That is one part of the story. Just to please come to 1947. 1947, we all know that on 20th of February 1947, Clement Attlee, the leader of Labour Party, has announced to the entire world that India would be granted independence by partitioning India into two independent states, India and Pakistan. On 14th August 1947, Pakistan was given independence. 1 day later, India was given independence on 15th August 1947. Pakistan was taken out. The condition was put against both India and Pakistan at the time of granting independence, stating that both countries would be the British dominion till both of them are coming out with independent constitution. Immediately, the first interim government has constituted the drafting committee consisting of the Dr. Ambedkar as a chairman and 6 other persons as members. The Indian drafting committee, taking 2 years, 11 months, and 18 days, have completed the constitution. And they placed it before the public and kept it for getting opinion wherever any improvement has to be made or whichever the article or provision are to be deleted. They just kept it inviting opinion from the public 6 long months. Then after 6 months, when they received various suggestions from various quarters, 2,000 amendments have been filed. And finally, on 26 November 1949, we have adopted the Constitution. Some of the provisions were also brought into force from 26 November 1949. And the rest of the provisions were brought into effect with effect from 26 January 1950. If you see Article 394, it says that the Constitution of India would come into practice with effect from 26 January 1950. I'm just indicating to enlighten one very grey area that when India and Pakistan were partisan, Pakistan was bestowed with 5 perennial rivers. I'm just talking to you in the context of how to nurture, how the liberty, life and liberty of Indian citizens have been nurtured, and how the life and liberty of the other parts of the Indian were completely devastated. Now what happened? When Pakistan was granted independence on 14th August 1947 with 5 perennial rivers, Jhelum, Chenab, Ravi, Indus, and one more river. India, the Indians were fighting for water. We are not able to get sufficient amount of water. But in spite of all these things, we are able to make, India is able to produce 3 times more than the agriculture produced than what we had produced before 1947. Not only the agricultural productions, even in the case of social, economic, and political development, India, I would say, stands far ahead of other developing nations now. But you take the case of Pakistan. It was a part of India in the year 1947, till it was Pakistan. Today, not even one single multinational company is able to go and settle their establishment over there. The reason being, the constitution which we are enjoying, in my assessment, in my judgment, I would say that is not available in the same philosophy which we have in our constitution in the Pakistan constitution. I will tell you one thing. The Pakistan has adopted the constitution after 9 long years. Only in the year 1956, Pakistan has adopted the constitution. On the day it was adopted, there was a hue and cry. The minority Hindus were objecting to that, saying that we are not safe with this constitution, therefore please recall that. Friends, in the year 1958, it was abrogated for the first time. Within 2 years, the constitution of Pakistan was abrogated. Again, they went for drafting the second constitution in the year 1962. It was also there for only 10 long years. But the concentration of power, the executive power, was taken over by the military. Because there is no proper safeguard like what we are enjoying in our constitution. As a result, the powers were taken off from the president by the military leaders. So 60 to 72, from 62 to 72, within 10 years, the second constitution was also abrogated. The third constitution was enacted only in the year 1973. Come to the case of Indian constitution. We have adopted only one constitution on 26 November 1949. Some of the provisions came into effect from that date, and the rest of the provisions have come into force from 26 January to 1950. But we have been standing as a role model. The reason being because of the vibrant constitution, the provisions embedded, framed, made in our constitution is speaking clearly that the life and liberty of people, the life and liberty of citizens, not only the life and liberty, the life and liberty of every person who is coming to this land will be safeguarded. I would like to repeat one thing, please. You must understand that I am not repeating the same article. Article 15, Article 14. The state shall not deny to any person equality before law or equal protection of law. Look at it now. The state shall not deny to any person equality before law or equal protection of law. And just give a small illustration. A foreigner goes to Chennai airport. His name is in the waiting list number 3. I'm sorry, waiting list number 1. An Indian, a resident, a Chennai resident is also going there. He wants to go to Delhi. In the Delhi flight, he is waiting list number 3. But can the airport authority, on the ground that the foreigner whose waiting list number 1 can be denied, and an Indian whose waiting list number 3 can be given the priority? Article 14 will not permit. That is a great piece of the Constitution. That is one of the beauties of the Constitution. That is the reason why we are just going. But we just come to Article 15. Here it says that the state shall not deny to any citizen. But here is a case now. But if you go to Article 19, it says all citizens shall have the following rights, which I mentioned to you now. So, when the Constitution of India, wherever it requires that the Indians should be given top priority, it gives top priority for the purpose of nurturing the life and the growth of the persons. Wherever it deems fit that as a person, equality has to be followed. The life and liberty of everybody should be followed. It also gives the equal importance to everyone. That is the reason why the Indian Constitution stands as a salutary document in comparison with other documents. I was just mentioning about Burma. Burma went out of India in the year 1937. Had Burma been with us, they would enjoy the same rights. Since they went out of the scope of the Constitution of India, today they are not able to enjoy the life and liberty. Let us go to Tibet. In the year 1950, when it became independent, for the reason best known to them, for 4 reasons, the Indian government took a policy decision. Tibet also should be given independence. In the year 1950, before the Constitution was adopted, Tibet was taken, and then they said that already can go separately, we can be independent. 4 reasons they said. 1, on the ground that there is a racial identity which is different from Indians. on the ground that your language is different from other parts of India, on the ground that your religion is different, your habits are different. Citing these 4 reasons, they gave independence to India. Within 1 year, what happened? The Chinese government invaded, attacked the small place, and then they annexed the China. Friends, we know that they do not accept any foreign interference. Today, many of the people, thousands and thousands of people are all infiltrating into India as the refugees now. It shows that the life and liberty of the Tibetans are not at safer hands. I'm just mentioning that the Constitution of India is being liked by everyone. When Burma was taken out, Tibet was also taken out. And then Pakistan went out. Along with the Pakistan, Bangladesh went out. Today, India stands as a role model in preserving the life and liberty of the people. I'm just indicating one small thing. We take the case of our neighbor, Sri Lankan people. In Sri Lanka, for the past 50 years, they are fighting on ethnic ground. The Sri Lankan Tamils and Sinhalese are fighting for their shares, their rights. There is no equality. There is no life and liberty. The reason being, I would say, there is no strong and vibrant constitution like the one we are enjoying. Therefore, we must salute the constitution and the wisdom that has prevailed in the minds of the founding fathers of the constitution for giving us a very safe constitution for us to live happily and peacefully. Friends, we do is the second stage of the life and liberty that is being nurtured by the Constitution as a Forerunner. We just come to 1950. In the year 1950, the first government was facing a very peculiar, tumultuous situation in the country. In the year 1927, in the state of Tamil Nadu, the Justice Party ruling this state, they were just thinking that people should be given some bonus, some incentive should be given. If you just go down to the village side, whatever, just take the case of 4 groups: barbers, sweepers, dhobies, scavengers. I will take the case of the sweepers and scavengers. I'm just talking about 1950. In the year 1950, if you are a village man, if you just go into the inside Tamil Nadu, in the village side, 50 years ago, the open defecation was the only remedy, the only chance. The people will get up in the evening, morning. Then they will go to do their morning ablution outside the village. On the outskirts, they will go and sit and they do the open defecation. Friends, the village panchayat would be employing these scavengers, these sweepers. We all know that only from the revenues which they are getting from, collecting from the village, the payments would be made to these sweepers, scavengers. These scavengers will have to carry a big basket on their head and they will be carrying a small plate. If you have seen it 50 years back, I have seen with my own eyes. I witnessed this incident. They will have to go in the morning and manually they have to remove all the human exchequer, waste that are all lying on the outskirts of the villages. More particularly, if you see that during this rainy season, these poor scavengers, sweepers, won't even be granted what you call even the sufficient basket or sufficient the plates to collect and remove all these things into their basket. Some broken plate will be there, some broken basket will be there. These poor people will be going, and then they will be collecting, removing, cleaning up all these areas. Just imagine, during the rainy season, these people will be going, collecting that. The rain will be just pouring. They will be collecting and carrying the basket, and whatever is there in the basket, if it is the seepage, it is leaking. The human waste and the soil, which are all collected, put in the basket, will be leaking. It will be dropping on the nose, dropping on the mouth, dropping on the chest, dropping on the face. This is one deplorable conditions of these poor people. The second part of this story is, I'm just coming to the first amendment, how the first amendment of Indian Constitution was made. I'm just giving you the background. The second part of this inhuman living of these people is, these people are all employed by the village panchayats. We have seen that there are downgrade, lower grade, and higher grade panchayats. If the village is able to get more income and it is graded as a higher grade, if it is lower grade, it doesn't have sufficient revenue. We as a judge, we are all sitting at a time in the petition with the madam is called for directing the panchayat, directing the collector, district collector, to pay the salary of these scavengers, their commoners. For 1 year, some of the village panchayat will not be in a position to pay the salary to these poor persons. Depending on the revenue which they are collecting from the village factory, from the village, the shops, and then the properties and all these things, the payments should be made to these people. But here is a case where in some of the villages, even the payments won't be made to them. Just imagine how the children of the sweepers, how the children of the scavengers will be taken care of. What will happen with the life in the local people? The government in those days, 1927, thought fit to give them some concession, and therefore they said, what is more important to nurture these people's life in the country? How to elevate them from the lowest rank to some reasonable level? They come up with one GO that is called a community. They said, these people belonging to the weaker section will be given some concession in the matters of admission in the colleges, professional colleges, and other colleges. What happened? One of the person in Chennai, the Chembagam Thurairaj, and there is one more person, Srinivas Ram, they applied for getting admission in engineering college and medical college. Chembagam Thurairaj applied to the Madras Medical College, but she was denied admission. But admissions, the vacancies were there. Similarly, another gentleman, Mr. Srinivasan Rao, he also applied to get admission in the engineering college. He was also denied, but vacancies were there. When they first him, they said that this is meant for these people. So they said, when Article 14 says the state shall not deny to any person equality or equal protection of law, equality of law or equal protection of law, on grounds only of sex, race, community, or place of birth, or any one of them. And Article 15(1) says that the state shall not discriminate against any citizen on grounds only of race, religion, caste, community, place of birth, or any one of them. How can you allow them? Then they also cited Article 29 subclass 2. 29 subclass 2 says that no citizen shall be denied admission into any education institution on the ground of religion, race, caste, community. Putting together all these three principles, three articles, they moved a petition before our High Court, saying that Article 15 is violated. Article 15 is one of the fundamental rights guaranteed under Part 3 of the Constitution. Article 13(1) says, 13(2) says that all laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are contravening or taking away the rights guaranteed under Part 3 of the Constitution, to the extent it is contravening. To the extent it is contrary, the same shall be what? Article 13. 13 says that the state shall not make any law which will take away, which will abridge, or which will damage the rights conferred by Part 3 of the Constitution, the first part of Article 13(2). The second part of Article 13(2) says that even if any law is made which is contravening the rights conferred by Part 3, to the extent it is contravening, shall be what? Therefore, please set aside this GO. The High Court, accepting the argument. Naturally, because Article 13, Article 14, Article 15 are saying that there cannot be any discrimination. Ultimately, the GO was set aside. The matter was taken up by the government to the Supreme Court. Supreme Court also confirmed the order. The Chambers won the matter before both courts. It has sent a huge hue and cry, a shock thing to the first government. 15 months have gone by from the date of adopting the Constitution. The first government, after realizing that this weak section should be taken care of it, a mistake has happened. Here is a case where I would like to mention one small thing. The Chembakam-Thurayarajan case could have been avoided. Had there been a smartness or alertness prevailed in the minds of the government of Tamil Nadu or the officers working then in the state of Tamil Nadu. I mentioned to you that when the drafting committee has drafted the Constitution, after taking 2 years, 11 months, and 18 days, they placed it before the public domain, inviting the objections from all the peoples, whether any improvement has to be made or any provision has to be deleted. 6 long months, the matter was there in the public domain, inviting objection, inviting anything for improvement. Friends, the state of Tamil Nadu, it appears, have not gone before the drafting committee, indicating that, see, this is the GO, this has been prevailing from 1927 till now. Therefore, this has to be protected for the interest of the weaker section. Had they brought to the notice of the chairman of the drafting committee, Dr. or any other members, perhaps the matter could have been taken care of it, and the proper provision could have been made in Article 15, like the 15 for which we have made through the First Amendment. But one thing I would like to tell you, when the drafting committee was consisting of 1 plus 6 members, that is, chairman plus 6 members, P.T. Krishnamachari was also from our place. And then Alladi Krishnaswamy here was also from our place. I do not know why this has not been brought to the notice of the drafting committee. Had it been brought to the notice of the drafting committee, there would not have been fight, there would not have been any unpleasant situation prevailed between the government and the courts. The matter could have been solved then and there. But ultimately, the government thought that this weaker section should be given. Otherwise, the life and liberty of the weaker section would be completely destroyed. Finally, Article 15(4) has been inserted, saying that nothing in this article shall prevent, or nothing in Article 29(2) will prevent the state from making any special provision for advancement of the weaker sections belonging to socially and educationally backward class of the citizens now. So, when Article 15(4) was belatedly brought in the meanwhile, what happened? Many casualties are happened. So, somehow or other, I must say that Article 15(4) has taken care of the life and liberty of the persons. And this is one of the very important facets of the First Amendment. Even if you go to the second part of the First Amendment, the first government of India, within 15 months from the date of adoption of the Constitution of India, they thought that when Article 39B and C are contemplating to bring an agrarian reform to avoid the concentration of wealth and only in few hands, they said, we will take away the unused lands from one hand and will give it to the landless people. So they have abolished what we call the Jamindari system. Some of the people in UP and some of the people in Madhya Pradesh and some of the people in Bihar, they question this. Madhya Pradesh High Court and the Allahabad High Court accepted that, dismissed the petition. But in the case of Bihar, the Bihar High Court has struck down this provision, 31A and 31B. What happened? 31A says that if the state government wants to bring in any legislation or any act for the purpose of implementing the direct principal state policy to bring in agrarian reforms, and in the process, the fundamental rights guaranteed under Part 3 of the Constitution is violated. On that ground, that law cannot be construed or deemed to be what? Article 31A. 31B says that even if the court, while entertaining the challenge on the laws made by the state, that it is violating or taking away the rights conferred by Part 3 of the Constitution, gives a judgment in favor of the person who is challenging and is striking down the law on the ground that the direct principle state policy cannot be given primacy, but only the fundamental rights should be given the primacy. Immediately, if the government places this act in the 9th schedule, then the judgments given by either the High Court or Supreme Court will be wiped out, and the act which has been framed by the states for the purpose of implementing the direct state policy to bring in the agrarian reform shall be preserved, shall not be questioned, shall not be taken as a void one. This is done. I want to make it very clear that the government on one hand wanted to just preserve the life and liberty, but in the judicial forums, the courts, the High Court and the Supreme Court are also trying to preserve the life and liberty of the persons. But they say that, but you must go only in accordance with law. Without Article 15.4, court said, please follow the rules and regulation. When the law says, Article 15.1 says that the states shall not discriminate, we'll have to go with the law. But once you bring in Article 15.4, once you bring in Article 31A and 31B, and bringing these laws, placing in the 9th schedule, court said, yes, we have to read together both the rights conferred under Part 3 of the Constitution and the direct state policy. In the case of Senbam Thuraidasan, the first case, they said that the direct state policy, namely the Part 3 of the Constitution, will prevail over the Part 4 of the Constitution. The direct state policy will have to give way for the fundamental rights. But after Article 15.4 was inserted, and then the 31A and 31B were also inserted by way of the First Amendment, only for the purpose of preserving, nurturing the life and liberty of the citizens. Court said, yes, now the Part 3, the rights guaranteed under Part 3, and the rights which are there in Part 4, the direct state policy, should have to go together. If we just go to the Minerva Mills case, they said that it is a complementary. Without the existence of one, the other rights cannot survive. It has been very well read and it has been mentioned very clearly. The point is, the government on the one side, the judiciary on the other side, they are competing with each other to preserve the life and liberty of the citizens. Friends, I will tell one small thing and then I will end my speech. As a forerunner, can you say anything that the Indian Constitution is a forerunner while nurturing the life and liberty of the citizens? I will tell only small three important, vital, interesting aspects. Our founding fathers, having been heavily inspired by the British model of parliament democracy, they have borrowed the British model of parliament democracy. In England, which is considered as the mother of parliament, the house of democracy. Friends, you must know that a finest lawyer cannot become Lord Chancellor. Lord Chancellor is the head of the judiciary of the United Kingdom. A finest lawyer, for the reason that he belongs to Roman Catholic, he cannot become the Lord Chancellor. Equality class has not been taken care of in Great Britain. From there, we have borrowed the British model of parliament democracy. But this problem was tried only by Tony Blair when he became the Prime Minister of England in 2007 by bringing the removal of Inequalities Act. By bringing in this act, a person who belongs to Roman Catholic was made to become the Lord Chancellor. Only in the year 2007. But you come to Indian Constitution. We adopted on 26 November 1949. Let us take the case of even 26 January 1950. From the day one we have adopted the Constitution, we have been following the equality class with the letter instead. In India, whether you are a Hindu, whether you are a Christian, whether you are a Parsi, whether you are a Saurashtrian or a Muslim or whosoever you may be, whether you are coming from east, west, south, or north, you are entitled to become the chiefs of India, the head of the judiciary. Article 15, Article 14 will support anyone, but that is not the case in the case of UK. Therefore, we can proudly announce to the world that Indian Constitution stands as a forerunner to the United Kingdom. That is one thing. We just come to US. We call United States of America is the superpower. We all know that the American Constitution was adopted on 17 September 1787. Friends, after the American Constitution was adopted, in the year 1787, the right to vote was given only to the men community, but not to the women community. Women were denied the right to vote. They cannot cast their vote. They cannot contest anywhere in any local election or higher elections. The situation continued not 1 year or 2 years, for 130 years. There was a hue and cry. There was a procession. There was almost a cold war taking place every now and then, demanding the right to vote to these people. Finally, after 130 years, in the year 1920, for the first time, the US government has brought in the 19th Amendment. In the year 1920, right to vote was given to the human community. Take the case of the Indian Constitution. The day one we have adopted the Constitution, we just go to Article 326. 326 gives adult suffrage to all persons, whether you are man, or female, or male. If you are above the age of 18 years, you are entitled to cast your vote. You are entitled to select your own MLA, your own leader, your own MP, your own Prime Minister. Therefore, the Indian Constitution stands as a forerunner even to the United States of America in the matter of preserving, nurturing the life and liberty of the people. Please come to the second facet. Not only when you compare India with UK and US, even in the Switzerland, the right to vote was given equally only in the year 1971. Go to Portugal, 1976, the right to vote was evenly given to both men and women. In the case of South Africa, the right to vote was denied to the women community, and the white women were granted the right to vote only in the year 1930. Look at the very interesting aspect. But when they were granting the right to vote to the white woman, they denied the right to vote to the black woman. But this very peculiar situation prevailed till 1993 in South Africa. Only in the year 1933, the right to vote was evenly given to all men, women in South Africa. If we just come to Kuwait, 2005, the right to vote was given to both communities, both men and women. And then in the case of UAE, the right to vote was given to both the men and women only in the year 2006. In the case of Bhutan, 2007. Put together, you have to demand equality treatment. We have to demand. We have to fight for that. But take the case of India. The moment the constitution has been adopted, we are living with the letter and spirit in terms of Article 14, equality class. Therefore, I would say proudly that Indian constitution stands number one as a forerunner in the matters of nurturing the life and liberty of the citizens. And then you will come to the judicial review. I will tell you that again, if you compare our Indian constitution, the judicial review is wider if you compare with the US constitution and if you compare with the British one. In Britain, the United Kingdom, the primary legislation is there, the secondary legislation is there. The primary legislation is one passed by the parliament. There we cannot challenge it. It is not amenable to any judicial review. Only in the secondary legislation, that is when the legislators are passing on delegating the powers to the other authorities. Only in the secondary legislation, if there is any violation, that can be brought within the judicial review. The reason is in UK, Parliament is supreme. But in India, Parliament is not supreme, only the Constitution is supreme. If you just see the Kolakna case, it says that you may have the power to amend the Constitution under Article 368, but you do not have the power to amend Part 3 of the Constitution. Of course, this has been reversed by the subsequent judgment in the 1973 Kesavananda Bharati case. But Kesavananda Bharati also said that Parliament has got power, but you do not have the unlimited power to the extent of abridging the fundamental rights, namely the basic structure theory is there. You cannot, the Parliament does not have the power to take away the basic structure. And therefore, it has put a full stop and made it clear that the Parliament is not supreme, only the Constitution is supreme. If you just go to the China, judicial review is not there. Why I am concerned, why I am just laying emphasis on the judicial review is a very simple theory. In the case of preserving the nurturing the life and liberty of the people, 42nd Amendment was brought in, inserting class 4 and 5 in Article 368. Class 4 says that Parliament is given unlimited power, including the power to amend Part 3 of the Constitution, Article subclass 4 in Article 368. And then the class 5 says that when the amendment is made, no amendment made by the Parliament can be challenged by bringing this amendment within the four corners of the judicial review. When it was put to challenge in the Indira states, the court, the constitutional bench, has struck down class 4 and 5, saying that you want to give unlimited jurisdiction to Parliament, by which you are inserting these classes 4 and 5, If you are giving unlimited jurisdiction, unlimited power to the parliament, what will happen? Anytime, any person can come and change the constitution. If they come and change the constitution, then what will happen? It will be like our neighbor. I do not want to say frequently, repeatedly. What is happening in the neighboring soil? There is no any person to the because every time the constitution is abrogated here and there, just like that. Therefore, the mineral states and also the Kesava and the Banerjee specifically put a constitution limitation on the point, saying that no doubt under Article 368 you have ample power, you have unlimited power to amend the constitution, including any parts of the constitution. But so far as the basic structure is concerned, the Supreme Court said that you do not have the power. The reason being, this will lead to what we call the anarchy, despotism, and unreasonable administration. Therefore, Supreme Court said that the basic structure cannot be cannot be interfered, cannot be changed. Why the basic structure should not be changed? I'm just ending in small thing. You go only on the basis of in democracy, you have to go by the majority of the people. If the majority of the people comes and says that, yeah, this has to be done. I'm just recalling what happened just long time ago. In the case of imposing the death penalty to Socrates, many of the people were supporting his death when he was administered the poison hemlock. But after his death, people were lamenting that our leader was wrongly killed. So majority decision proved to be wrong. Take the case of Jesus Christ. When he was crucified, majority of the people supported his death. But after 3 days, there was a revolt every now and then that Jesus Christ was crucified wrongly. Majority of the decision proved to be wrong. Come to India. In India, we have the Sadi system. It was perpetuated by the majority of the men community. And subsequently, and after a long time, Dr. Rajaram Mohan Roy taking the support of Lord fully and panting to abolish the Sadi system. What is Sadi? We all know that. See, when a husband dies, the wife has to go into the funeral fire just burning, and she has to die by stepping into that, leaving behind the small children. Look at the social problem caused by the Sadi system. The Sadi system has created irreparable loss for a long time. A wife, after the death of the husband, will have to go voluntarily and step into the funeral fire, leaving behind the children, male member, female member, son and daughters. For example, what will happen to the sons and daughters? The son will become antisocial element. The daughter will be pushed to the child marriage or a flush trade. Is it not going to cause social problems? Finally, my point is, unless the majority of the people supported a particular custom, would not have continued for a long time. So majority decision cannot be taken. Therefore, this was the view taken by the Supreme Court, both in the Kesava and the Banerjee, and also in the Nirvana case. Therefore, they said that you may be majority, but you do not tinker with basic structure theory. Friends, this judicial review principle is there only to safeguard the life and liberty of persons. Finally, I would say only one thing, that I would tell the world community, more particularly the people and the leaders in Burma, Tibet, Pakistan, Egypt, Syria, Iran, Iraq, etc. If you would like to nurture your countrymen's life and liberty, and if you find it very difficult to do so, do not worry. The answer is there in India, in Article 14, in Article 15, in Article 17, in Article 19, in Article 32, in Article 226, in Article 326. Please come and see how the Indian Constitution is functioning and how it is nurturing the life and liberty of the persons. Ultimately, you will be the beneficiary, and your life and liberty, your countrymen's life and liberty will also be blossomed in full form. It is I thank the organizer for having invited me to give a small sharing of my thoughts on this topic. Thank you so much.
Thank you, Your Lordships. I now invite Mr. Ashok Pati, Madras High Court's advocate in Madras High Court, to render the vote of thanks for the day.
Good evening, good afternoon, one and all. It has been an excellent day for us with a lot of energy. And Her Ladyship, Justice Indira Banerjee, has started the address with the right note, and Her Ladyship had traveled us right from Kesavananda Bari to the present case of Puttasamy. And that did not leave His Lordship Justice Raja to take it forward in a very high style, covering up the entire issue and gambit of the articles. I don't think so any of the articles within the framework of the topic today was omitted. His Lordship was pleased to address every single point of it with very detailed explanation and anecdotes or examples. That clearly was very educative. Thank you, my lords, for taking your Lordship's times for enlightening us with this topic. I also thank His Lordship Justice R. Mugasamy, Justice Nagamuthu, for being present here and raising the occasion. And my thanks are also towards all the participants who had participated in large numbers and for their patient listening and for the entire enlightenment. I thank one and all. And also my thanks goes to the organization who have been consecutively organizing these webinars. Thanks one and all.
Thank you, Ladyship.
Thank you. Thank you so much.
Thank you, Ladyship.
So I have taken so much of time. Please excuse me now.
No, it
You
was
gave
very,
me
very good.
only 1 hour, but I didn't look at the wall clock here. I forgot to look at the wall clock. Yeah.
Time actually flew, my lords.
Thank you, Lordship. Your Lordship is on mute.
Oh my God. No, it is not on you. Oh, you're not understanding?
I said Raja exceeded his time because I took away a lot of his. Okay.
Thank you.
Thank you.
Bye-bye.
Thank you.
We end the session with this. Thank you.